Greetings and salutations. Welcome back to another instructional episode from the Legal Beagle podcast. We are doing due process today. Due process. Now, this isn't an exhaustive deep dive into this, but it is an overview and all the key elements that I thought that was important for doing due process. So if you're looking for legal writings and all your exact specifics, this may not accomplish everything you want, but it is a good overview of what due process means and what it requires. So without further ado, let's get into it, ladies and gentlemen. Okay, due process. Origin of due process guarantee. Only 4 countries have due process in the world. They are the United States, India, Canada, and South Africa. Thinking about moving to another country, I think that's a small list right there for due process. Although the Fifth Amendment to the United States Constitution is the first instance in which a written constitution limited the powers of government. Chapter 39 of the Magna Carta confirmed on June 19th, 1215, and it declared no free man shall be taken or imprisoned or dissid, I don't know, sorry, I apologize, or outlawed or exiled or anywise destroyed, nor shall we go upon him, nor send upon him, but by the lawful judgment of his peers or by the law of the land. Constitutional provisions for due process of law generally. The guarantee of due process found in the Fifth Amendment of the United States Constitution declares that no person will be deprived of life, liberty, or property without due process of law. The 14th Amendment declares that no state will deprive any person of life, liberty, or property without due process of law, and is a limitation only upon the powers of the states. All these people talking about the 14th Amendment means you're a citizen of the United States. Well, without the 14th Amendment, the states could violate the life, liberty, and property. So that's why we put the due process in 14th Amendment as well as the 5th Amendment. The cornerstone due process is the prevention of abusive governmental power, and to prove a due process claim, the plaintiff must show that he or she has been deprived of a protected interest without due process of law. Due process as related to common law and fundamental rights. The common law is the foundation of that which is designated as due process of law. Common law rights must be distinguished from, as they are not the equivalent of, fundamental rights. Fundamental rights are recognized by the United States Constitution itself and are protected by substantive due process. Common law rights are protected only by procedural due process. And we'll get into the difference in procedural and substantive due process here in just a minute. Nature and scope of due process guarantee generally. The guarantee of due process of law is one of the most important to be found in the United States Constitution or any of the amendments thereto. It has been stated that no other phrase known to the American and English law comprehends so much that which is basically vital in the protection of human rights and the redress of human wrongs as the phrase due process of law. The notion reflects and describes the concept of ordered liberty. The Due Process Clause guarantees more than fair process and the liberty it protects includes more than a mere absence of physical restraint. A state's obligation under the 14th Amendment are not simply generalized ones. Rather, the state owes to each individual that process which, in light of the values of a free society, can be characterized as due. Defining due process. The difficulty of defining the phrase due process of law has been repeatedly recognized. It would be very difficult, if not impossible, to frame a definition of the term which would be accurate, complete, and appropriate under all circumstances. The term due process of law asserts a fundamental principle of justice rather than a specific rule of law, and thus is not susceptible of more than a general statement of its intent and meaning, which are ascertained in the history of its specific applications to cases requiring judicial decisions. So hard to put into words exactly what all the all-encompassing due process of law is, but we try to give it a generalization that a just society would apply to what the real meaning of due process of law is. So keep that in mind. The primary guide in determining whether a principle is fundamental principle of justice protected by the Due Process Clause is historical practice. Defining due process, judicially crafted definitions. The term due process of law includes all the steps essential to deprive a person of life, liberty, or property. It includes all the forms and acts essential to its application and to give effect to it. The means that may be employed to accomplish the purpose of the law is the process. In other words, process is the mode by which the purpose of the law may be effected. Increasingly in modern jurisprudence, the term has come to represent a realistic and reasonable evaluation of the respective interests of plaintiffs, defendants, and the state under the circumstances of the particular case. Judge is supposed to have this grandiose thought and envision of what due process means, and he's supposed to look at each specific case in regards to the defendant, plaintiff, and the state and make fair judicial rulings based on things that are under this vision, but yet fair to all parties, right? In the concept of this grand vision. Obviously, we see that this doesn't always occur, but this is what we strive to be, right? This is what America strives to be. Differing protections in procedural and substantive due process. In its present stage of development, the concept of due process of law has a dual aspect, substantive and procedural. For the Due Process Clause of the 14th Amendment not only accords procedural safeguards to protect interests, but likewise protects the substantive aspects of liberty against impermissible government restrictions. The procedural and substantive components of the Due Process Clause are distant from each other because each has different objectives and each imposes different constitutional limitations on government power. What procedural processes do generally? Procedural due process is a guarantee of fair procedure. While due process of law in its procedural aspect has never been a term of fixed and invariable content, just like we stated in the definitions, hard to define the all-encompassing vision of due process. But we try. This is what we're trying to do. have to keep that in mind when we go into the individual aspects of cases, of different circumstances. State's interest, the defendant's interest, the plaintiff's interest, etc. The essential elements of procedural due process of law are notice and the opportunity to be heard prior to depriving a person of his or her protected property interest. So that's what the summons is about, and that's what the court hearing is about, right? So you have to be noticed, have to be able to be heard. After being heard, then a decision can be made based on the circumstances of the situation, whether to deprive or each of that individual of life, liberty, or property. The Due Process Clause calls for two separate inquiries. The court first asks whether there exists a liberty or property interest of which a person has been deprived. Second, if so, it asks whether the procedures followed by the state were constitutionally sufficient. Interests comprehended within the meaning of either liberty or property for these purposes include interests that are recognized and protected by state law and interest guaranteed in one of the provisions of the Bill of Rights, which have been incorporated into the 14th Amendment. Violations of due process. A violation of procedural due process may occur even where the damages are only nominal. Doesn't have to be a big situation, but if someone steals a nail, that is your property. That nail is pretty nominal, but it is nonetheless your property and can be adjudicated as a loss of life, liberty, or property. In fact, for purposes of procedural due process, a damage remedy is not an essential component of constitutionally adequate review procedures. Read that again. In fact, for purposes of procedural due process, a damage remedy is not an essential component of constitutionally adequate review procedures. Judgment without such citation and opportunity lacks the opportunity to be heard, lacks all the attributes of a judicial determination. It is judicial usurpation and oppression and can never be upheld where justice is fairly administered. Tests applied in determining procedural due process requirements satisfied. To determine what process is constitutionally due, the courts generally have balanced three distinct factors. One, the private interest that will be affected by official action. Two, the risk of an erroneous deprivation of such interest through the procedures used and the probable value, if any, of additional or substitute procedural safeguards. And three, the government's interest, including the physical and administrative burdens that any additional or substitute procedures would install. If the procedures are changed, they need to be reviewed in light of what due process is, vision of due process. Fundamental requirements of procedural due process. The core of due process is the right to notice and a meaningful opportunity to be heard. The fundamental requirement of due process is an opportunity to be heard upon such notice and in such proceedings as are adequate to safeguard the right, meaning it's jurisdiction of all parties and needs to be able to properly have the authority to grant whatever ruling he has. Can't go before a court that has no authority and expect due process. Exceptions. Exceptions to the principle that a person must be afforded notice and an opportunity for a hearing before he or she is deprived of his or her rights can be justified only in extraordinary circumstances. Thus, except in extraordinary circumstances in which some valid governmental interest is at stake that justifies postponing a hearing until after the event, the government must, that infers a duty, must provide a hearing before depriving an individual of a protected interest. So if they have some event that they know that they're going to deprive someone of interest because of some health and safety, whatnot, they must provide a hearing beforehand. What is not required for procedural due process generally? Procedural due process, unlike its substantive counterpart, does not require that the government refrain from making a substantive choice to infringe upon a person's life, liberty, or property interests. Instead, it simply requires that the government provide due process before making such decision. So we said, if they're going to do it, they know they're going to do it, or going to have to because of some safety or well-being of the community, and have to make that, they must have a hearing before that decision. Did they do that with the recent pandemic? I don't know if there was. We haven't uncovered them yet. Procedural due process does not require perfection at every stage of a process, and unlike substantive due process, does not require that liability turn upon the culpability of the offending party. Due process and limitations on police power. Limitations on police power generally. The police power of the state is limited by 1, the rights guaranteed by the Constitution. 2, the necessity of a legitimate public purpose, health, welfare, safety, these type things. And 3, a reasonable exercise of the power. So that's pretty self-explanatory. The legislature may not, under the guise of regulating in the public interest, impose conditions that are on their face unreasonable, arbitrary, discriminatory, or confiscatory. Moreover, the police power is, by its nature, exercisable only restrictively, as restriction is implicit in the power itself. Just like in the Middle District, when we couldn't go in to file our papers because we had to either have a jab or a diaper on over our mouth, then that was an unreasonable and discriminatory action by the chief judge outside of a judicial proceeding, which would give her judicial immunity because she was acting administratively for all people walking into the building. She could not possibly know everyone's health and choices and religious beliefs before making that decree. Yet, the U.S. Marshals have imposed it religiously. Generally continued. Although the judicial branch of government is the final arbiter of the limitations that apply to police power, the notion that courts may freely assume the role of arbiters of public policy is very much exaggerated. For the courts should especially avoid assuming such a role in the face of a statutory scheme that enunciates its own policy considerations. This comes back to why we need our law schools to teach law again, and why we need our judges to learn that law and have the balance, to be able to see what the vision should be, what the state is trying to do, and bring them into a cohesion that will not affect the rights of the individuals, but yet can accomplish the state's objective. The limitations on the police power have never been drawn with exactness by the courts, and its boundary line cannot be determined in advance by any general formulas. What they're saying is you're going to have to take it on a case-by-case basis, and that's why we need fair arbiters sitting on the bench. Territorial limitations on police power. The police power of a state generally may not be projected beyond its territorial boundaries. Thus, for example, a state cannot, under the police power, regulate out-of-state activities conducted by an organization located in that other state. However, a state consumer regulation is not invalid because it also protects consumers outside the state. Territorial limitations continue. A state's police power jurisdiction statutes are not invalid as violating equal protection or due process, where they subject persons residing within a few miles of a city's corporate limits to the city's police, sanitary, and business licensing powers, and to the criminal jurisdiction of the city courts, even though they do not extend the right to vote in municipal elections. If you live just outside the city limits and you're subjected to the courts and these things, this is a due exercise of police power. According to this, even though you can't vote for these city officials, they can still extend power to you. Although the government need not employ the least restrictive means when exercising its police powers, the means must be narrowly tailored to achieve the desired objective. Meaning that if they put in place a statute or a code that they are charging you with, and it doesn't completely eliminate the crime, such as that face diaper, because it didn't do anything to protect anyone, then it cannot be implemented because it didn't achieve the desired objective. Judicial challenges to means of exercise of police power. A legislature's police power is not unlimited, and the validity of any mandate promulgated under it is for judicial determination. Thus, while the legislator may enact laws which impinge on constitutional rights to protect the health, safety, and welfare of society, any restriction is subject to judicial review to protect the constitutional rights of all citizens. Judicial challenges to means of exercise of police power. Constitutional. Although the legislature may, under its police power, limit the constitutional rights of personal liberty and property by enacting laws to protect the public health and safety or welfare, any such laws are subject to judicial review and constitutional analysis, which would be the strict scrutiny. When you go into the federal court, I want a strict scrutiny on this particular statute or law and make sure it conforms with the Constitution. That's what we're supposed to compare here. Does it fall in line under the supreme law of the land, Constitution? Yes or no? The general factors considered in determining the constitutionality of police power measures are no different from those that have relevance to the determination of the constitutionality of other types of litigation. Applicability of constitutional provisions to limit exercise of police power. The structure and limitations of federalism allow states great latitude under their police powers to legislate concerning the protection of the lives, limbs, health, comfort, and quiet of all persons. However, the police power is constrained by the limits under the state and federal constitutions that apply to all governmental actions. Must fall in line. all of these liberties in order to be able to do that. So this goes back to a crime. Have you harmed someone or their property? Yes or no? If you have not harmed someone or their property, then there really is no reason. Otherwise, there's no reason for the state to come in and exercise authority over you, because you've committed no crime and you've harmed no one. And so that would be discriminatory, because they are picking and choosing who they want to do deeds, yes and no. But that can't happen. It must be all under the federal Constitution. And that's why if you harm someone or their property, then the state can come in and take the complaint from the citizen and use that to prosecute you. But you must have someone that says, I've been harmed. Otherwise, the state cannot do so. And if they claim, like the face diapers, that you're going to harm someone else, they have to prove it. And they have to prove that their remedy will completely remove all threat. Otherwise, it can't just be a general, well, we think you should stay behind this line. Well, why? Right? You need a reason, and it needs to completely eliminate the evil that it is directing action against people for. A constitutional right cannot be abridged by legislation under the guise of a police power regulation. That concludes our overview of due process today. I hope you've enjoyed it. Please leave a comment in the section below if you want to hear something else. If you have a specific topic you want us to go into, we'll be happy to put that together and move forward with it. But until then, we'll see you next time. Thanks for watching.